If you've been falsely accused of domestic violence, that you were arrested, you have a court date, one of the things you may be wondering is, well, can the victim be prosecuted for making a false police report? And in this video, which is number 4 in a 7-part series about common misconceptions, I'm going to be discussing exactly that. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish how to represent yourself at your domestic violence restraining order hearing and win. If that is something that you are interested in, sometimes you get arrested. You also get served with a restraining order. When it rains, it pours. You can get your free first class in the course via the link down below. Okay, so let's jump right in. So misconception number 4 in this 7-part series is that the alleged victim of domestic violence is likely to be charged with making a false report if they change their story. Now, this scenario can happen if the alleged victim is on your side, wants this whole thing to just be dropped, but knows that per misconception number 3, they can't get the charges dropped. So they may be considering submitting a statement to the DA. They may be considering testifying on your behalf and saying basically that they lied to the police. So that's scenario number 1. Scenario number 2 is that the alleged victim does want you to be prosecuted or doesn't care, but lied, and you can prove it, or at least very close to prove it. So what happens then? Can they be punished? Now, the truth is that in the state of California, it is extremely, extremely unlikely for someone who was initially identified as the alleged victim in a domestic violence case to be ever charged with filing a false police report, with perjury. It is extremely unlikely. The head district attorneys in each county are politicians. And in this era where their narrative is basically that if you are a victim of domestic violence, especially if you're a woman, and their narrative, and the main reason why they won't allow alleged victims of domestic violence to drop the charges or really have any say in dropping the charges, is because they believe that this is all part of a cycle of violence and that you are suffering as the alleged victim from battered woman syndrome, and so you are just going back into the honeymoon phase of the cycle and trying to get this whole thing dropped, or you are just so afraid of the abuser that you feel forced, coerced to try to get charges dropped against them. That is their narrative. And so because of that, we have many police departments within the state of California whose policy it is that when they come out for a domestic violence call, they make an arrest. It doesn't matter if they don't see any evidence, doesn't matter if there aren't any injuries, doesn't matter if both people say nothing happened. Their policy is still to make an arrest. And we also have district attorneys' offices who make it their policy to not prosecute victims of domestic violence, even when they get on the stand and their story is totally different than what they told the police. Even when they testify more than one time for a case and their story changes, the DA's offices do not prosecute them. Is it possible that they could go ahead and decide to prosecute? Yeah, I guess. But it's also exceedingly rare. But there's another non-political reason for them to not file charges against someone who they initially identified as the alleged victim. It's that their case would probably suck. Now, maybe not necessarily for perjury, but you can always have somebody who misremembers. I used to, before I focused on domestic violence cases, I handled murder cases, attempted murder, and I had multiple trials where we won by convincing the jury that my client acted in self-defense. Now, if someone acts in self-defense, that means that the other person committed a crime against them, right? The other person was attacking them, and they simply defended themselves. So do you think when they finally let my client go that they charged the other person? They don't. They never do. And a key part of that is that if they were to charge that other person, the other person's defense would be self-defense. And in fact, I'm sure their attorney would be jumping up and down saying, hey, they even charged the other guy first. The police came out. They arrested the other guy. They actually brought him to trial. And that's how strongly they felt that he was the primary aggressor. And so they would probably win based on self-defense. Now, this is fact specific. But the point is that it is extremely unlikely that the alleged victim of domestic violence is going to be prosecuted for anything that they do involving testifying in the case or giving statements in the case. So that may make you happy if you and the alleged victim are still together and you just want this whole thing dropped to move on with your lives together, or it may make you really upset if you are falsely accused and there's really no consequence to the alleged victim for lying. And this is actually an issue that someone brought up with me recently. Carlos and his wife Anna have been together for 10 years. One night they had a really loud argument. Anna was really upset. She had found some texts on Carlos's phone and believed that they were completely inappropriate. She tells him to leave the house. He refuses to leave the house, and so she calls 911. And during that call, she says, "And he hit me." She's not thinking clearly, she's emotional, but it didn't seem like they were taking her that seriously when she said that he wouldn't leave, because it's his house too. The police come out, she says the same thing, and she thinks, okay, well I can just tell them that he hit me and they'll make him leave. But instead, she's very surprised to see that they arrest him, which is what they will do. So now Anna has bonded Carlos out of jail. They have hired a criminal defense attorney to represent him and try to get these charges dropped before his first court date. And as part of that, the criminal defense attorney asks Anna, do you want to give a statement? Are you willing to write a letter in support of Carlos, clarifying that actually he did not hit you that night? So Anna has two choices. So choose your own adventure. Choice number one is Anna says no. Anna says, I'm not going to do that. I'm afraid of getting in trouble. I mean, Carlos is the one who was texting inappropriately anyway. Look, we hired you. You're a good attorney. You should be able to get this dropped even without my statement. Before court, the DA is looking through all of the police reports and everything else that's in the files, trying to figure out which cases they are going to file. And they see, notably, that Carlos does have a great character packet. His attorney has written a great letter about him. This is an attorney that they respect. But they see that what's missing is there's nothing from Anna. If this is his wife of over 10 years and she's not even willing to write a letter in support of him or taking anything back, then they're probably not together anymore, and probably Anna is going to want to testify against Carlos. So the DA thinks, great, okay, so we're going to put this on the to-file pile. And so charges are filed against Carlos. Choose your own adventure. Choice number two. Anna consults her own attorney, who informs her, just as I have with you in this video, that it is extremely unlikely that she is going to get any charges filed against her, and that it would probably be a cakewalk to get them dismissed in the event that some wayward DA did decide to file charges against her for making a false police report. So Anna writes a letter and she tells the truth. The DA, again, looking through this stack of files, trying to figure out which cases should be filed as felonies, which as misdemeanors, and which they should give a second chance to the defendant to, read Anna's letter. Look at the police report and see, you know what, there really weren't any injuries here. She had an old-looking bruise on her arm, but it does make sense, her story, that she wanted to get him out, that she was upset. They listened to the 911 call and see, yeah, they weren't taking her seriously at first, and then she bolstered it and said, oh yeah, he hit me. And so they decide that they are going to drop the case. When you're charged with domestic violence, especially when it's your first arrest ever, you want to do everything that you possibly can to try to get the charges dropped. And if you are the alleged victim and you want to have the charges dropped, if it were me, I'm writing a letter. If I want these charges to be dropped, if I don't want my husband to potentially become a felon, I'm writing a letter, because on balance, that makes the most sense. I hope you found this video helpful. If you do have a criminal case in California that you need help with, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.